Hello and good afternoon. Welcome to our third and final session of this symposium on children's identity rights in the context of emergencies. This particular panel will focus on the context of children on the move. And just before we get started, I would like to thank our partners who have co-sponsored this event, including the Committee on the Rights of the Child, UNICEF, UNHCR, Special Representative for the Secretary General for Children Affected by Armed Conflict, as well as CRC Connect, the European Network on Statelessness, Family for All, the Global Campaign for Equal Nationality Rights, the International Commission on Civil Status, and as well the International Federation on Social Work. Just before we get started with the session, I'd like to remind people that we have interpretation available. And so you can find the languages at the bottom of your Zoom screen. And basically it's all self-explanatory with the exception of the Arabic translation is labeled as German. So if you require Arabic translation, please choose the German option. I also just want to mention that we are sharing the bios and the agenda for this session in the chat box because we would like to spend as much time as possible on having our presenters share their presentations. Also, because of that, we are unable to take questions immediately. But if you do have questions or comments, or if you are working on any of these issues and would like to share your experience, if you could kindly just share that in the question answer box, we will hopefully be able to review those questions and comments and eventually revert bilaterally if possible and where necessary. I think I would also maybe just to mention that this presentation is being recorded. And so we will ensure that the recorded version is available and shared with you once that is ready. And with that, I'm going to hand over to our moderator for this session, Ms. Mia Dumbach, who will go ahead with the session 3. Thank you.
Thanks, Denisha, for that. So now we come to this last session for the day. We're talking about emergency settings, and as we know that emergencies can result in children moving. Sometimes they're unaccompanied, sometimes they're separated, sometimes they are moving with their families, but they are moving. And so with that, we'd like to first have our first speaker today is Ms. Razia Sultana from the Rohingya Women's Welfare Society, who will talk about the denial of identity as well as nationality for Rohingya people, including children in exile, and the implications for these children. Thank you, Razia, because I know that it's late where you are, but thank you for staying with us and sharing with us your experience.
Thank you so much. I'm Razia Sultana. And thank you for letting me say something about the Rohingya issue. I am belong with the Rohingya community in Bangladesh and brought up in Bangladesh. And I am a founder of RW Welfare Society who works for the Rohingya women camp. And I will say that the Rohingya refugee crisis is a genocidal humanitarian disaster that has gone rapidly. Not everyone is aware of what exactly is happening to these people. This is an intensified conflict between the majority Buddhist Burmese and the minority Muslim who were formerly living in the Arakan, its new name is the Rakhine State, within the province of Myanmar. First, there are still questions why Rohingya face this identity complexity and what is the motive. The Rohingya were rendered stateless and left wondering helplessly about their identity. The problem with Rohingya identity is that it encompasses multi-ethnic groups. The answers to the question why the Rohingya minority was not considered an ethnic group along with the recognized 135 ethnic group in Myanmar has its political, ideological, and cultural dimension. As international law, we know any ethnic group has the right to restore their unrecognized ethnic identity. The Rohingya identity crisis began when they were devastated citizenship law. The Rohingya people used to have a national NRC like everyone else in the country, Myanmar, and old name is the Burma. Upon the introduction of discriminatory policies on Rohingya by Nawin in the 1970s, the NRC were taken away by various measures. The Myanmar government has effectively institutionalized discrimination against the ethnic group through restriction on marriage, family planning, employment, education, religious trust, and freedom of movement. The first exodus was in 1978 when the military began the Naga Dragon King to find the Dragon King operation to find and take action against the Persian military junta deemed to be illegal migrants. The operation targeted Rohingya in Rakhine State. The government claimed that the Rohingya people were foreigner rather than an ethnic minority of Myanmar. During this operation, many Rohingya had their official documentation taken away by interagency team of inspectors. As a result, more than 200,000 Rohingya fled across the border into Bangladesh in 1979. They were repatriated after a bilateral agreement between the authorities of Bangladesh and Myanmar. However, most of the Rohingya who returned were homeless, excluded from all government sector, and stayed without documentation, proper documentation. The Rohingya refugees are threatened by perpetual stateless. Most of these refugees are women and children. The Rohingya have no official evidence of citizenship, no passport, no education or official career, as well as many restrictions on their movement. This issue of Rohingya identity is so crucial since this ethnic minority will remain stateless forever. The dilemma of the Rohingya is either to stay in Myanmar and be killed or to escape to neighboring countries and be considered refugee. The crisis is addressed as an outcome of illegal migrants. The late mass exodus of Muslim Rohingya to Bangladesh began on August 25, 2017. After some Rohingya militia attacks, about 30 police posts and an army group. This was followed by a massive military counter-offensive by the security force in Myanmar and horrific atrocities committed against Rohingya women and girls by the Burmese military, particularly sexual violence. Moreover, from the time when the military crackdown broke out in August 2017, more than 1 million Rohingya had fled Myanmar to neighboring Bangladesh. The attack on Rohingya village in August 2017 were a systematic effort to drive them out and had been described as an ethnic cleansing, but truly it is a genocide. And I will say that there are so many times refugees come and go, and still in the 90s, refugees are stuck in Bangladesh registered camp who are maybe have a refugee status, but they have no right for proper education, proper decent life. Even if they have a unit checker, but they have no right to move even in Bangladesh, and even if they wish to go outside, but there is no proper mechanism for them. It's like they are nowhere people. After the 2017 influx, and these people are take shelter in Bangladesh, Cox's Bazar refugee camp. But we say it's refugee camp, but these people have no refugee status, and they are mentioned as a forced displaced people. And this it is almost a 5 year. There is no improvement, about the repatriation, and about their life is just stuck in the camp, and the children's future is, I think they have no future, because there is no formal education, no livelihood, even if the camp is surrounded with the peace, and day by day aid is become decreased, and the proper essential things are not getting. It's a worse situation for them. And every time we are telling about the repatriation issue, but it still is in the paper, and international community only they are maybe provide some aid, but it needs to be more focus of how to the issue, because this people cannot stay in other countries. And yes, I'm thankful to Bangladesh because they give them the shelter, but they cannot live here forever. And we also, as a result, we have seen, because there is no education, no opportunity, children become aggressive. And we also see, because this is a border area, and trafficking and drugs is not an issue. So these people are stuck in this criminal activity. So it is a very threat for not only for Bangladesh for this reason. And I will also I'm going to tell you about the massive massacre in the last 2010 and 12 in Chitwe in Rakhine State. These people, most of the Rohingya and some Muslim and also other ethnic, they are forcibly displaced in Myanmar, and they are in now IDP 10, and their future also bad, because children not getting any opportunity in their own country, and they are not allowed to go their own land. What they see is not so far, it's just like 1 mile ago. But I am asking the international community. That time everyone said that this is an internal problem, but I'm saying that this is land of these people. What happened to the land? And when you see this land is now in the industrial zone, and it is funded by the international community. So how can you say it is an internal conflict? It's not an internal conflict, it is international, because everyone focus on the business, not the real issue. And I'm not only talking about the Rohingya issue, there are other ethnics also facing the same situation inside in the Myanmar. Thank you. Thank you so much. And
thank you, Razia. It's really heartbreaking to see what's happening to the Rohingya people and the fact that they can't access basic services. I also saw that you had written notes, because some of the interpretation was a bit, the sound wasn't fantastic. Perhaps we can have the written document, or we can share that with the panelists, with the other participants afterwards. What I think we will have now is that Razia has shared a video of some of the implications of people with lived experience that we will show. It's going to be, the English translation will be in the chat function for everybody to understand what's happening. Thank you.
এই দেশে তোরার মাইতে হাতে তো দিছিল তোরা তো
মারে মাঝে তো মালিক দিলো আর আমার বেজিদের আর রত্তং ঘরে ঘর করেন কই কি আল্লাহর আন্দার তো ঘর কাছি তোদ নিজের দেশে লাই আর মনে হলে মরিলে যাইম বয়া হইরে নিজের দেশে যাইরে বলি হার গনি মারি এড়ে বেশি শুকরিয়া জানো শুকরিয়া আলহামদুলিল্লাহ কিয়ামত মার তখন ফরাইতা না আরে লজেলি কো যাবা গই যাইম বই যত সাথে হ্যাঁ যাইম বই ইয়া কালা আরে থাকি দা ইয়া কি আরাত দেনে দেনো আর কোন অতন নয়া শুকরিয়া আলহামদুলিল্লাহ।
Thank you, Razia, for sharing that video of these ladies and the heartbreak of not being able to be back in their country without an identity or being recognized. We will come back to you at the end for some questions, but before then, we now move to South Africa, to Daniela Lima Rodriguez and Liesl Mueller from the Centre for Child Law, University of Pretoria, and to look at the use of strategic litigation to protect children's identity rights. Thank you.
Can you guys hear me? Okay, so I'm Daniela Lima Rodriguez. I'm 14 years old. Basically, how it all started, I was born in Cape Town, 2018, and my parents had immigrated from Cuba in 2016. When I was born, my parents were no longer residents of Cuba because of a few laws, and they weren't weren't citizens of South Africa either, so I couldn't be categorized in anything. The laws kind of made it so I fell right in between. And thank you, after years of fighting, there were these amazing lawyers that finally got something to change. I'm now a Cuban citizen, and I have the right to a South African citizenship if we would want to proceed further. Growing up, I didn't really understand what happened because I was too young to understand, but I remember the first time I really understood what happened. I was watching a YouTube video that they'd made of me when I was around 6 or 8-ish, and I just started crying because I realized that my life, if nothing happened, was not going to be the same as other children. I wasn't going to be able to go to college or just live out my dreams that I really wanted to happen. When I realized what happened, it definitely, it left me with a few, like an identity crisis of sort, because I'm labeled as an immigrant in the country I was born in, and I don't know anything else of South Africa. And yes, I identify with Cuba because my parents are Cuban. I should be legally Cuban, which is what I am now. But I feel like I should also be South African. I grew up here. I grew up with this culture. When I went to Cuba, finally, I experienced culture shock. There are just so many children that will always be stateless because they don't have the facilities, or their parents are just too scared, or they can't stand up and say, my child needs this, or they can't fight for this. And honestly, there's so many issues that you never really think of, like, that come with it. I remember my mom, we were talking about this today, and she mentioned the fact that the reason I was never allowed to go anywhere without them was because how were they going to identify me if something was up? If they could only identify me through blood work, because I wasn't in any database. And that's why I can't go anywhere without them. And this trauma that comes along with it, the anxiety, the constant pressure, the who am I? What am I supposed to be? All of this, and so many people deal with it their whole lives. I was lucky enough that I finally got the Cuban citizenship at just I got it when I was in 2019, so when I was like 11. Some people grow up until they're old and they have to live with that forever. And if I'm being honest, I still feel like that clueless child that doesn't know what's going on. All that she knows is that something is wrong and it's going to affect her future if nothing changes. Yeah. Thank you.
Thank you, Daniela, for that amazing testimony of what it really feels like for children not to have an identity, a legal identity, and to be stateless. And now I turn to Liesl Mueller from the Centre for Child Law, which are these amazing lawyers headed by Carabo. Okay, thanks.
Thank you. Good afternoon. And I'm very proud of you, Daniela. That was a lovely speech. And I was Daniela's lawyer at Lawyers for Human Rights all those years ago. And it was really a difficult path, as she says. And I'd like to just tell you one or two things about the litigation that we do here. So I do the same kind of litigation on children's identity rights at the Center for Child Law that I did at Lawyers for Human Rights, but now particularly focusing on children. And so there are crucially four, or let me say rather 5 aspects to the litigation work that we do. And the first one, and let me just say that the people that we represent are always representative of a larger group, and we strive always to resolve a strategic problem. So when we have clients in our law clinic, we start to see trends and we pick up on strategic issues that we'd like to intervene on. And one of the first things that we do always in these cases is ask the court to make a declaration of rights. And like Daniela was saying, that there's always this uncertainty hanging over your head, and being able to prove your rights and being able to show somebody, whether in government or at a school, that you are entitled to the rights, to your fundamental rights, is incredibly stressful. And so one of the first things we always do in our court cases is to ask the court to declare the person's right to the nationality of South Africa in this case, which is what we did in Daniela's case. The second issue that we address quite frequently in South Africa is the issue of proof. So we often deal with cases that are actually about birth registration, but because birth registration is so crucial to acquiring and proving a nationality, of course, that is something that we see as crucial to the process. Now, this is probably actually the most of the cases we receive, and there are various aspects to that. One is that the Department of Home Affairs in South Africa actually applies a higher onus of proof that a court would. And when we take these cases to court, we prove them on a balance of probabilities and get an order which orders the Department of Home Affairs to register a birth. One of those issues that we're dealing with currently is that children of single fathers or fathers who had a child with a foreign mother are required to do a DNA test to prove their paternity. And so at the moment, we are involved in a litigation case where we are proving paternity through other means. So when I say that, you will all be familiar with the presumption of paternity. So it applies where parents are married. It means that when a child is born within wedlock, we assume or we presume that the husband is the father until somebody else proves otherwise. And so this is an important protection for the child. And what we are arguing in this case is that DNA testing is not reasonable, and that there are various additional ways to prove paternity, which should be included in the presumption of paternity. For instance, in South Africa, we have customary practices where if a child was born outside of wedlock, and there is a traditional customary procedure which is negotiated in the community, that is a way to prove paternity. And so we're asking the court to basically develop the law and make the law regarding presumption of paternity broader. Then we also do the kind of work where we force implementation. So for instance, we have really good safeguards in the law. The one that applied to Daniela was the otherwise stateless provision. So we've had this in our law for 25 years, and there's no implementation. So we asked the court to force Home Affairs to draft a regulation which allows application, and that has still not happened. And so that's very sad, but there are some follow-up cases that we're hoping are going to deal with that. We also do the kind of thing which is called a structural interdict. So which is something we would have done with Daniela's case if we knew how hard implementation was going to be. But what it does is we say, that the respondents must do X, Y, and Z, and they must report back to the court in 6 months to tell the court what they've done. So that's something that really helps in these cases. And then my last point that I would just like to make is that we have at the moment quite a few, we don't have the data, but we have cases where children have come into the country after birth. So they're not born in South Africa, but they are stateless. And they are migrant children, often foundling children. And we are considering litigating on this gap in the law. So that's the last thing we do with litigation, is that where we see a gap, we address it and ask the court to order the respondents to fill that gap. And then we also make suggestions on how we think that should look like. So those are the most, I think, interesting things we are working with at the moment. And then I will respond to questions if need be. Thank you.
Thanks for that, Liesl. I think that's just a very brief overview of the excellent work that the Centre for Child Law does. But now we move on to Nicholas Knorr, the Secretary General for the International Commission on Civil Status, who will be speaking to us about normative instruments that can facilitate the issuance of civil documentation in cross-border contexts and emergency settings. So over to you, Nicholas. I think, Nicholas, you just have to move a bit backwards from your screen so that we can see your face.
Thank you. Thank you very much. I hope that everything's fine. Thank you for the invitation also. ICCS is an international organization that has adopted 34 conventions and 11 recommendations on civil statutes in the broad sense. A key element exists, the multilingual forms that are annexed to most of the instruments. These are standard forms of civil statutes documents, uniform and therefore the same in all contracting states. Why can they be considered as simplifying elements? The first aspect is that the multilingual forms circulate between the contracting states without requiring legalization, which is a considerable saving of time and, of course, of money. The second aspect is that translation issues are avoided. The translation into the official languages of the different states, parties, of course, to the convention, of the different entries in the document is provided on the document itself for the oldest conventions, or in a lexicon for the most recent ones, which makes it possible to understand the document through a codec system. The third aspect, the multilingual forms are civil statutes documents, and they have the same evidential value as acts issued in accordance with the rules of domestic law of the issuing state. The most famous example of our conventions is Convention number 16 on the issue of multilingual extracts from civil statutes records. It's in force now in 24 states. Annex 1 contains a multilingual model of birth certificate. Once obtained from the authorities of the place of birth, it will be able to circulate in all the other contracting states without formalities, without the need for translation, which means that it will be able to provide its effects rapidly without any real obstacle, which is essential in urgent situations. That convention has been modernized by Convention number 34, which entered into force between Germany, Belgium, and Switzerland on July of this year. The scope of application is now broader, and the legal regime remains the same for birth certificates. Other states have already expressed interest in that convention, and we expect many ratifications and accessions in the short term. Other elements may also be interesting in our conventions. I don't have the time to develop, but I will just give you one example. Convention number 22 on international cooperation in providing administrative assistance to refugees. Very helpful, of course, both for the refugees, but also for the states, the authorities of the different states concerned. So I think that my time is up. I could give you many more examples of mechanism in our conventions, but I think that the easiest way for you to have such informations is to go on our website, so the website of the International Commission on Civil Statutes. Thank you very much for your attention and your interest in the ICCS.
Thank you, Nicholas. I think that it's a really good recommendation for people to have a look at this website and to have a look at these 34 conventions that have been drafted and really will help for this cross-border recognition of these important civil status documents, because we keep saying without these documents, we will not have an identity and that children are at greater risk of exploitation. If you could stay for the end, Nicholas, we have some questions for you, but now I hand over to a very dear friend and colleague, Benoit van Kilsbroek, Committee on the Rights of Child member, and who will also present on the committee's work and also take us forward with some questions with the panelists. Thanks, Benoit.
Thank you so much, Mia, and thank you for inviting me in this very interesting and important event. First of all, I would like to thank Daniela for her intervention. It was so moving, and she just tackled all the important issue that I wanted to address. As member of the committee has different ways to address the issue of right to identity, and especially in the framework, in the frame of children on the move. First of all, we have issued many general comments on the topic, and that deals with the issue of right to identity. I will come back on that in a second. We can decide on individual communication. Anne Skelton already talked about some of them, but I will highlight another one. And then we, of course, have recommendation to the states that are issued in our concluding observation after the monitoring process when we conduct our monitoring towards every state. So we have three main general comments dealing with children in the migration. First of all, the number 6 from 2005, which deals with the treatment of unaccompanied and separated children outside of their country of origin. And then we have the 22 and 23, which deals with general principle and the state obligation regarding the human rights of children in the context of international migration. The main points that I can highlight now from those general comments is, of course, the importance of birth registration. It's extremely important, it has been highlighted many times today. We know that the fact that a child is not registered, doesn't have proper identity documents and so on, it entails a lot of risks of becoming stateless, of not having the possibility to enjoy many other rights, and including the risk of child marriage, trafficking, forced return, forced recruitment in the frame of child labor, and so on. So the committee recommends to states, and it has been highlighted in those general comments, to immediately register at birth, and this irrespective of the migration status of their parents, because very often what we can see is that many states do not register children when the parents are migration status, and that's of course not acceptable. We ask also the states to remove all legal and practical obstacles when it comes to birth registration, and to prohibit also sharing information concerning the status of a person with immigration enforcement authorities, because otherwise there is a risk for those authorities to use the fact that a person is not with proper identity rights in the country to use it against a person, and this will of course limit the possibilities or the situation where parents will try to identify and to seek for identity rights of their children. In some cases, migrant children or families may have used illegal or irregular documents to migrate and to enter into a country. And the committee very often highlights and recommends the importance to ensure that this is not used against the person. We still recommend also other principle and action from the states to take every appropriate measure to restore the right to an identity, the right to a nationality, to avoid statelessness, and globally also to ensure that all the dimensions of the right to identity are taken into account, including sexual orientation, religion, and other issues. We also, and this is extremely important, we recommend to the states to ensure that there is an access to a child-friendly and gender-sensitive, safe judicial and non-judicial remedies. The importance of remedies has to be highlighted extremely clearly. Otherwise, as we have heard from Daniela, there is no possibility to ensure that a child can recover its identity. I could talk at length also about the cases where we have been intervening, especially for unaccompanied minors in the situation of children who were unable to prove their age, and so that's the issue of the age assessment. And through the OPIC, individual complaints mechanism, we have had to recommend to many states to set in place a system which will guarantee the right for children to have the right assessed, the age assessed in a right and genuine manner, including benefiting of the benefit of the doubt when there is no documents, and other procedure that will cover and ensure that the child has the right to an identity, including its age being assessed properly. I will end up here for the sake of the time, and we can pass to the question to the panelists.
Thanks for that, Benoit. There's definitely much more that can be said, and we promise everybody another event next year with a longer time for each speaker. But Benoit, if you wanted to start the facilitated discussion with the different panelists, that would be great. Thank you.
Yeah, with pleasure. I wanted to ask to list, first of all, thank you very much for your intervention. It's so great what you are doing in South Africa, and we see how important access to justice is in this kind of situation. But what kind of legal solution and or policies do you see that would be required in South Africa to ensure that identity rights of children on the move, both accompanied or unaccompanied, are really protected as a general measure?
Yes, well, we are very worried about this right at the moment. We have, similarly with the rest of the world, concerns about state security when it comes to identity, issuing of documentation. And so the government approach to documentation and granting of nationality is from a security point of view. And not only undocumented children, not only stateless children or the children of unmarried fathers, but refugee children, asylum-seeking children, any child outside of the family norm, the nuclear family norm, will at some point find it difficult to register a birth or to get a document. And so we are going to be doing a lot of advocacy at parliament level and along with court work. But we need a massive shift in the government's approach to this problem for this right to be protected.
Many thanks, Liz. Indeed, the political will is, of course, key in such a situation. Otherwise, we won't make concrete progress. Razia, thank you very much also for your intervention. It was absolutely moving, and indeed, the situation of Rohingyas is one of the most worrying situations and a very large scale. I wanted to ask you, as an ethnic minority which is denied of identity rights, many of whom are now in exile, what role can human rights bodies like the Committee on Rights of the Child, in which I'm sitting, and civil societal organizations working on identity rights can play in order to support the restoration of identity rights of the Rohingyas? What do you expect from the international community in this regard?
Thank you. Thank you for your question. Yes, this is very complicated issue because Rohingya were ignored, not only authority, Myanmar government, even the other ethnics. So these, because after the coup, some maximum ethnics, they are now understand what happened to the Rohingya, but not everyone. So in my issue, we have to involve the international community and try to understand that what exactly happened to the Rohingya and who are the Rohingya. Because most of the time we have to face the same question that why you are in this state, and because our religion is Islam, we are Muslim, but other ethnic, most of the Buddhist. So there is so many conflicts about the history. The history is so many times is decorated, and Arakan itself is it was not part of the Burmese, I think Myanmar, but it is somehow history or about the global politics is now with the Myanmar. But this thing is not understood by our other ethnic people. So I want to give our approach and to, first we have to introduce that what is exactly the Rohingya and why we are denied our, the real history, denied our rights, and we are belong that land. So this is the thing I have to be again and again ask everyone. You should be give approach, and I ensure that if everyone is understand, because we are now asking about the democracy. Yes, democracy will come. Even in the 2010 it came, but Rohingya are just excluded from in the scenario. But now, if again, I wish it will become again. But this time also we want back our rights. So this is thing I am requesting everyone in the international community. Thank you so much.
Thank you, Razia, and I can tell you that you are doing a wonderful job in just raising awareness and making people see and understand what is at stake and how much this population is suffering of this situation. Thank you so much for your testimony and your work. It's so crucial, and I can tell you that your voice is reaching in the international community, and we will continue to raise awareness on that. Nicholas, I wanted to ask you also something. I found it very interesting, your approach and the work you are promoting. And especially you mentioned the fact that the translation of civil registration document is, of course, very a problem that happens very often. And if we don't need to legalize those documents, it has the potential to unlock many problems that children on the move can face and help establishing and protect child identity rights. In case where there is a limited application. So what are, in your view, the barriers for more universal application, and what are the longer term solutions that need to be implemented to address these challenges? Of course, you have the convention that you mentioned. Probably the ratification of those conventions is extremely important, but I let you explain what exactly you think that would help us in improving the situation.
Yes. Thank you very much for your question. I think that most of the countries still believe that legalization is a kind of protection for them. Civil statute concerns sovereignty for most of them. So they need that protection. To find solutions, of course, we need to promote the different instruments existing in that field. I'm very often surprised by the complete ignorance by many states of such instruments. So bilateral conventions, of course, most of the states know that they can conclude such cooperation conventions, but multilateral tools are very often ignored. So I think that we need to stress on that particular point, and that's what we're doing at the ICCS at the moment. I think that many states completely ignore our organization, and so we try to promote it in Europe, of course, but also in Africa, in America, in Asia, just to have more ratifications for our instruments, because very often when people are aware of the existence of such instruments, when they discover them, they consider that they are very good tools. But we really need to promote it, and we need also your help for that, of course.
Many thanks, Nicolas. Indeed, those conventions are not so well known, and we need to continue highlighting the importance of them. And at the end of the day, it's also a support for the states. It makes the work of the states more easy and more accessible. And of course, it will ease the situation of migrant people themselves, because they will avoid the burden of going through legalization and translation. So thank you so much, Nicolas, and then I give the floor back to Mia.
Okay. Thanks, Benoit. To conclude, I see that there are a number of questions in the chat function, but we will not have time, as we said at the very beginning, to answer those, but we will share them with the panelists. And then if they are responded to, we will respond back to the individuals that pose those questions. But to end today, I'd like to ask all the panelists in this last session, starting with Razia, and then Daniela, if you would also like to answer this question, also Liesel, and then Nicolas, and then Benoit. A final question to you all, but in that order. If you could highlight one or two positive developments, and what do you think we can do as governments, UN agencies, civil society, to build on those developments? What would be your one message to close off for everyone? Thanks. So starting with Razia. Thanks, Razia.
Can I? Can you hear me?
Yeah, we can hear you.
Okay. One thing, don't forget us, because I know the situation after the Ukraine issue. I'm not blaming anyone, but the Rohingya issue is like now in the shadow, and the thing is now become very worse. And it just don't act like, because I know the fund fund for the Rohingya always there. But not only we are not only working for only fund, but we need to be forward about our rights. And I know there is so many ways international community can do. So this is my request, not only for aid, but we have to forward for this people's rights, because they cannot stay in a small area, and they have the children's future. And because they even can't think that their children can go to school, because I think UNICEF and UN, they know very well our formal education is forbidden in Bangladesh. So let's try how to make our children's future. So this is my request. Thank you.
Thank you, Fazia. I'm not sure, Daniela, did you want to say something as well for us?
So I'm not a professional or anything, obviously, but I do think that it would definitely improve the kids' mental health if you find a way to make Home Affairs realize how much of an issue it can be. I'm not trying to put the blame on them, but they kept appealing and appealing and appealing, which made the process longer, which would mean more anxiety, more stress, more pressure, because it's like you finally won, but they won't give up for something that's just a basic human right. So I think making the process shorter, or finding a way to try and make it shorter, would definitely help a lot. Make them aware. Thank you.
Thanks, Daniela. It's a very good point. It does seriously affect people whose rights have been violated when these procedures take so long. Thank you for that. And Liesl, did you have something you wanted to say?
Yes, thank you. We will do all we can, Daniela. We will, I think there are two things that I'd like to add to what Daniela said, is that I think we really need to work on awareness, and that will have to include the children who are affected and their parents, and including telling people stories, which I think has been most successful in changing people's minds on the issue. And then the second thing I think is just to keep reminding people and ourselves that we are dealing with children's rights. And so we cannot approach it from this issue from an immigration or a state security point of view. And that we must keep bringing the focus back to a child's rights approach, and that the child firstly is entitled to certain things. And then if the state or whoever else is involved wants to object to that, a certain amount of rights must be in place until something is proven otherwise. So we must think about that, I think. Thank you.
Thanks, Liesl. And Nicholas?
Yes, thank you. Positive development, I think, of course, the entry into force of our last convention. It's a modern convention, a modern instrument, and I think that we have some good signals about the interest of different states, but also of international organizations or international associations. The importance of the questions of civil status in general, and of course the rights of children is now, I think, clearly understood by most of the actors. They know that they have to do things to create new rights, and of course to use the international conventions that already exist.
Thanks, Nicholas. I hope that many, many more states will sign on to Convention 34, but also the other ones, of course. And Benoit.
Thanks for this last word, Mia. I would like to just highlight some positive result of individual complaints. So we have had to deal with many complaints coming from the same country. It was Spain, dealing with the same issue that was concerning the age assessment. So we had really to go in depth in those situations and to make a lot of recommendation to the state of Spain. Also to encourage them to improve the global approach of unaccompanied minor and age assessment. And at the end of all those decisions, we can see that there was changes in the policy of Spain. So they have had a lot of internal discussion, and they adopted new approach in this. And so this is an example for other countries that would like to follow this good approach. And so that means that on the one hand, don't hesitate to bring case to the Committee on the Right of the Child under the OPIC, individual complaint mechanism. But of course, since not so many states have ratified the OPIC, we need more states to ratify the OPIC and to allow children to have access to remedies. If a state wants to take children's rights seriously, they need to ratify OPIC. Otherwise, it means you give rights to children, but you don't give them the possibility to challenge the situation where their rights haven't been fully implemented. And so I think that, as Daniela was also saying, the testimony of children, and also the fact that we now understand how bad it is on the mental health and the enjoyment of all children's rights, we need to have more voices like Daniela's, on the one hand to denounce the problem, but also to show that when there is a solution, this goes in the direction of a better implementation of children's rights. Thank you.
Thanks, Benoit. Thank you, panelists. A fantastic last session to end this day. I think that overall this event has shown the importance of identity rights, the need to continue to promote awareness about the effects of not having an identity on so many millions of people in so many areas, that we can't forget them because they're not on our news, but they are suffering. We've heard the testimonies of Ferle, Daniela, and the Ukrainian children through their drawings. We can see the harm that it's doing, not only to their physical development, but also, as Daniela has said, is mental health issues. And we also heard from a number of different presentations from UNICEF, UNHCR, and the civil society actors, the importance of working together with the community, with people with lived experience, also twinning different services to make sure that people can go to the one-stop shop to establish their legal identity. But we've also heard that there is a lot of work left for us to do on behalf of child identity protection, and I'm sure Institute on Stateless Inclusion. We look forward to working with you all to make sure that identity rights of children are better preserved and re-established quickly, like the convention says. And so I leave it to Denisha to close. Thank you, everyone.
Thank you, Mia. And just also to say to all of our panelists, including the ones from previous sessions who are still with us, thank you so much for participating in this event. I think everyone will agree it was a really extremely interesting and engaging event. I know that we have some of the feedback has been, it would have been nice to have more opportunity to engage with the panelists. And so we do take that on board, and we'll keep it in mind for our future webinars and other events, but also just to say that this is, again, hopefully just the first in a series of different types of events we may be doing on this topic. So I'd like to thank everybody. Was there a hand from you, Mia? No? Okay. So with that, I would like to close this symposium, and I wish everybody a wonderful evening. Thank you very much for your participation.